Ready.
All righty. Folks, could have your attention again, and we'll come back to order for our last docketed item of the day. And as always, I'll call on Ms. Fox to read that docket, please.
Docket PZ 16-017, application has been filed by David Adams for a record plat for property located at 3106 Halls Hill Road, Crestwood. The applicant is also requesting a road frontage variance for a proposed tract. The property is zone R2 residential and CO1 conservation.
All righty, Ms. Alvey, would you introduce the docket, please?
Absolutely. As Ms. Fox stated, this is a twofold request. One is for a record plat to clear up some previous divisions of land, and then the second is, as part of that record plat, the applicant is requesting a road frontage variance for proposed tract. The property is located at 3106 Halls Hill Road in Crestwood. The property is zoned R2 residential and CO1 conservation. The parent parcel started out at 16.82 acres, and I'll go through the history of the divisions and hopefully be able to explain that thoroughly for you. This is the current outline that we have in our GIS system. Granted, it is not correct based off of minor plats that were recorded, but this just kind of gives you an overview of an aerial of the property, and it shows all the different homes that are located there. And again, this is an area view that shows the existing drives and structures that are located on the individual parcels. This is the current zoning. The property is divided. Part of the property is zoned CO1 and part of the property is zoned R2 residential. And then this area over here is zoned AG1, but is not part of this parent parcel. Site history, this property has not been the subject of any cases before the Planning Commission, so there is no previous actions before the Planning Commission regarding this property. The applicant applied for a minor plat on March 25th, 2016 to create a 2.585 acre tract that did not have the required 300 feet of road frontage. This is the minor plat that was submitted, and you can see this is the tract here that is being that was requested as a sell-off. And then you can see down here, the road frontage for this was 93.58 feet, requiring a variance because the requirement is 300 feet. The applicant surveyor was advised to request a road frontage variance, which would be heard by the Oldham County Board of Adjustments. But during staff's research of the property, it was found that there had been numerous sell-offs and numerous minor plats where some were recorded and some were not. During staff's deed research, it was found that a lot was consolidated via minor plat, but a home had been built on it and was receiving a tax bill for the lot. So and then at this point we said a meeting was called with the applicant and his surveyor and attorney to discuss the issue and division history of the property. This is the parent tract here, everything in red there. The applicant purchased 16.82 acres in August of 1991. In July of 1992, the applicant created 3 tracts from one. So they created Tract B and Tract C. In January of 1993, Tract B was sold to Laura and Vincent Smith. So this tract was then sold. So this is the first division. They went from 1 tract to 3. In December of 1996, the applicant created and sold off a 1 acre tract. So this will be called Tract D. So then this tract was then created. So now we have 4 tracts. In January of 1999, the applicant created and sold off a 1 acre tract, which this is Tract E up here. So at this point, we have 5 tracts. The applicant transferred Tract C to themselves in October of 2000 and re-recorded the minor plat creating Tract C from a survey dated May of 1992. This was to clear up an issue whether or not that this tract was legally created correctly back from a survey in 1992. So they re-recorded a survey that showed the creation of Tract of tract C there. Okay, in January of 2004, a deed of correction was filed for tract D. And with that, on that survey, that was the deed of correction for tract D, the survey filed showed that it consolidated tract C into the parent tract. So basically, tract C then went away. There were future minor plats that were reviewed and approved by staff in 2007 and 2008, but were never recorded, changing the shape and size of tract E. After meeting with the property owner and surveying his attorney, it was decided that a survey of the entire property needed to be completed based off the recorded minor plats and what was physically on the property. So this was the final record plat that was prepared by Dave Garber as the surveyor that shows all of the tracts. And if you recall, this was originally tract C here, and then this was a house that was constructed. Building permit wise, it was supposed to be on that tract C. It was built over the property lines. But then again, tract C went away when they did a deed of correction on tract D. So when that happened, we ended up with two primary structures on one tract. But with this proposed reconfiguration of tract C and the creation of tract F, it does clear up that we don't have two primary residences on one tract. The home that was constructed on tract C, which technically does not exist, was constructed over the property lines and actually located on tract A, resulting in two homes on one parcel. Tracts B, D, and F will share an existing 30-foot access easement, and tracts A, C, and E will share a new 40-foot access. And then you'll see here, this is the 30-foot access that serves, the yellow access easement serves the properties in red, and then the green access easement serves the properties in blue. So that kind of gives you a breakdown. There's two drives. One drive serves 3 tracts of land. The other drive serves the other 3 tracts of land. This is the entrance of the first access easement that we spoke of that would be on the right that serves the 3 properties. This is the house located at 3116 Halls Hill Road. And if you look at the map that I provided at the bottom of it, that gives you the location of where it is on your record plat. This is 3116 Halls Hill Road. This is tract B. This is the property to the right of the first access easement. This is 3106 Halls Hill. This is property F. This is the house and the 2.5 acres that he is requesting to be cut off in the tract that would require the road frontage variance. This is the house that's located on that tract. This is the north view, just looking on from the first entrance out onto Halls Hill Road. This is the south view, and this is the driveway into the other 3 parcels. This is the entrance into the second set of parcels. This is 3201 Halls Hill Road. This is tract E. This is the one that was in the far back left corner, if you see on the vicinity map there. And then this is the home and barn that is located on tract C. And that's the barn as well on tract C. And then you would actually come up the driveway, go this way to the house, and then you would go around the barn to get to tract E. This is just an area view. This is part of tract C to kind of give you the lay of the land, what it looks like behind the house, or in front of one house, behind the other. So it's what's there in the middle, and part of tract A, just the open space. This is the view looking from the back property, looking down into Halls Hill Road at the 3116 house. It's hard to see, but that's the roof of Ms. Jones's house. Garber Chilton Engineers and Surveys was tasked to perform an overall survey of the land and prepare a record plat to clear up all the old plats, survey what was physically on the property, and request a road frontage variance of 206.42 feet for the proposed tract F. And again, this is the proposed reconfiguration of tract C and creation of tract F, which requires the road frontage variance of 206.42 feet. And that, again, that's just a zoomed in version of the minor plat of that creation, tract 4. I'm sure that was probably clear as mud because it took me a long time to figure it out myself. So I'll be happy to answer any questions that you may have at this point.
Sally, thank you very much. That is, yes, very confusing. So I'm sure we'll have some questions as we
Sure.
move forward. But Commissioners, do you have questions for staff at this point, Mr. McWilliams? And then Mr. Horton.
Is this right now?
That is correct.
This is the latest and the greatest?
Yes.
What we're looking at is,
Yes. Yes.
are there, just a couple things come to mind. One has to do with ingress and egress.
Private access can have can serve 3 properties. So,
So do we have any ingress and egress issues with what's shown here?
no, not from the minor plat, because this access here, it serves tracts F, B, and D. And then this access here serves tracts C, A, and E. So there couldn't be any further division without some type of new curb cut here.
Or road construction,
I'm sorry?
or road construction, private road construction.
Right,
I mean,
a drive.
So there's not a drive?
Not for tract C. They use this access easement that goes through here. That access is for tract C, tract E, and tract A.
And that's okay, we're okay with that? Okay. Isn't there something about the creation of a certain number of lots or selling off, and if you do so much, you got a subdivision?
Mr. Urban?
well,
Or,
that's been an issue on this property, but over time, they've done these minor plats, and that's why it's in front of the planning commission today, is because of the creation of these lots. And actually, tract A doesn't have any road frontage.
Correct.
yeah, I was gonna say that. Where's-
Yeah, and there's a division line.
Isn't it required to have?
Well, there's a division line, if you look on the plan, there's a division line through here. Everything this way is R2, everything this way is CO1.
It says AG on the,
It says CO1 on my map.
oh, I'm sorry, on the next property, sorry.
So is the road frontage an issue or not?
Well, if a home, that's clarification we can get from the commission today. If the home is placed, if this is divided, if the home is placed on this side of the line, it's in R2, which does not have a road frontage requirement.
Right.
It just has to have a 150-foot width at the building line. If the house is placed on this side of the line, then he would have to come back for a road frontage variance. Because there would have to be, I can't see how many acres, it's 3 acres. It'd have to have 300 feet of road frontage. So it all depends on, my interpretation is, it all depends on where the house is placed. So if the house is placed in the R2, he doesn't need a road frontage variance. If the house is placed in the CO1 section of the land, of the lot, then it would require a road frontage variance. So at the time, if this is gonna be constructed, it may behoove the planning commission to make, if it is approved, make part of a condition of approval that a surveyed plot plan showing the zoning division line to confirm the location of the house and the zoning classification at the time of the building permit. That way you know for certain where the house is gonna be placed, because like I said, this lot here, this house was built for this lot that went away.
That's if it's intended to be sold as a building lot.
Correct.
Say again?
That's if tract A is intended to be sold as a building lot.
If tract,
All the other lots are clarifying that, okay, now you got houses on real lots where they're supposed to be.
Right.
Tract A is the only one that doesn't have a house.
Okay, so, should we take action on this without some sort of declaration?
I think get further through your procedures. You're still at staff report level.
Maybe you could ask the applicant or their attorney.
Okay, I'll defer any more.
Okay, and then,
Thank you, Amy.
Okay, thank you. Did I see another hand down here? Dr. Arvin, and then,
Is there one tract that still has two houses?
No, not with this, not, currently, yes. Currently, yes. But with the new reconfiguration of the Tract C will take on that house that was built over the property line. It will be on its own tract. So with this reconfiguration of Tract C and the creation of Tract F, that takes away the two houses on one property. And Tract A has no house, yes, sir. You are correct.
Dr. Arvin, anything else that you have on that, sir? Okay, let's move to Mr. Horton and then Ms. Bonet.
Thank you. I'm still trying to figure that out. Two, I guess, technical questions.
Sure.
On the drawing here, it says track 3. That's the little bitty part right at the very
at the bottom.
And it said it's dedicated to public use. Was that done as a matter of the survey and
Right.
simply delineating that as what it is because it's already in the right of way?
They required additional road right-of-way at the time that this was divided.
So that becomes the right of way for that piece of property. The other question then, at our chairs today was a letter that came in from an individual, and they were talking about here about notice not being postmarked at a particular time and not being received at a particular time, et cetera. Is that a problem for this hearing, or?
Our requirements are notification to adjoining property owners no less than 7, no more than 21 days prior to the hearing.
Okay, so
It was advertised in the Oldham Era, I think it was 14 days before the hearing date, and then they were notified no less than 7, no more than 21.
so it complied completely?
Correct.
Okay, thank you.
That's the
Thank you, Mr.
KRS
Chairman.
requirement.
Thank you, Ms. A.
All right, Ms. Bonet?
Is it an issue that Tract D and Tract B also do not have 300-foot frontage, considering they're in the CO1?
They're only required to have 150 feet because anything under 2.5 is 150. Anything
Okay.
over 2.5 is 300.
So because of their size, they are
Yes.
not required to have? okay.
Correct.
Thank you.
And those aren't being changed at all.
Right,
That's just a clarification of the sell-offs that have happened off the master parcel.
Right.
So anybody that owns B and D doesn't have to worry.
Or
Nobody.
E.
Or E. Those are not being changed by this.
Right.
Yeah. But yes, you're correct.
All right. Yes, Ms. Crosby?
At the time of all of these 6 lots being developed right here, not say developed, but platted,
Yes, ma'am.
did any of them come before planning and zoning, or they all came at staff level for these little cutoffs here?
They all came at staff level as a minor plat.
And you all allowed 6 minor plats on one piece of property?
It was before Amy Alvey. So.
And some of
yes.
them were during my recess, so
Yeah.
that's why this is
I was
all
not currently
being,
employed at the time that this occurred in this department.
yeah.
Because I've been here too long to know that we never, when you get to a certain number and
Right.
you know, they always come before us. I am appalled at this.
All right, any additional questions for staff before we move into the presentation by the applicant? Okay, seeing none, we will now move into the presentation by the applicant or representative and others in support of the application. Mr. Craig Mile. Just,
Hello again.
y'all were sworn in earlier, so I think we're good on that, but we will get your name and address just for the record.
Beach Craig Mile, attorney for Mr. Adams, the applicant, at 105 South First in LaGrange.
Okay. Will you have anyone else speaking, testifying besides
No,
Mr.
just
Garber?
Mr.
Okay,
Just Dave Garber.
all right. Go ahead, proceed.
Well, I hope you all followed all that. Right off the bat, I'd point out that if Tract F was 1/10 of an acre less, we would be looking at 150-foot road frontage rather than 300. But the line was drawn straight there before all this surfaced. Basically, all we're trying to do is clear up the tract, okay, as to what it really is, so that the GIS system can get corrected, and so that the record can be corrected. I mean, we debated what to call this, and it is deed of correction, whatever, but just a record plat recording of what is actually there, regardless of rights or wrongs in the past. You know, what happens is when somebody wants to sell off a piece of land, and you know, you get to sell off one piece of land every year, unless you do so many tracts within so many years. So I don't know that that was violated, but if, say he wants to sell off a tract of land, they take the minor plat in to the administrator, his assistant, they look at it and they say it looks okay, and then it gets approved. They may or may not sell that piece of land or that tract, and so it just kind of goes away. Well, you know, prior to Jim, somehow or other, these things got put into the GIS system and whatever. We're just trying to correct what's actually there versus what is in the system, and correctly show the tracts of lands as they are. Essentially, the separation between what do I have to do here?
Right side,
Right corner?
right bottom corner. There you go.
Okay, well, that's close enough. The line through the middle here that separates CO1 from R2 is perhaps some of the culprit. And that if you look at the requirements of CO1 versus R2 zoning, one of the primary differences in CO1 is it has a minimum road frontage requirement, whereas R2 zoning does not even have that requirement. Hence, there's no reason for Tract A to have a minimum road frontage requirement if the property is built on the left side of that line. It's kind of these situations where the Oldham County line goes right through the middle of somebody's house, and you go to Oldham County or you go to Jefferson County. Here, and the other problem created by the dual zoning here of CO1 and R2 is that, but for Tract F being in CO1, we could have gone under the, arguably could have gone under the panhandle exception for flag lots, you know, in which you create a flag lot that allows for easements or access to a piece of property under the subdivision regulations of, on page 23 of the subdivision regulations. There are flag lots are required or allowed as long as you have 40 feet. So you can like just have this little, it's kind of like an easement, but you can have a little 40-foot flag lot, which the flag is called the panhandle. You could have had one of those, but they're not applicable, we believe, in CO1. So what we ask for here is a variance from the 300-foot road frontage requirement in CO1 in which Tract F exists. Okay, so what Mr. Adams intends to do is to, in Tract F, there's an old house there that's been there that forever. It's a little typical ranch small country house that is the original home, I believe, of the area. And that area is cordoned off in Tract F, which would then separate the two residential properties on one piece of land, which previously Tract C existed. In this drawing here, Tract C included Tract F. So there were two homes on there. And so we're trying to correct that. Okay, so this will correct that. Tract F will now be a separate piece of property. Tract A, Tract C is just too big, so there'll be, Tract A potentially up there with, I guess would add one more home into this area. This configuration right here is the correct, according to a professional land surveyor. Dave's measured it, and this is what we would request that y'all approve, so that the administrator can then take this one to supersede and replace all the other confusing ones, if for no other reason to clear up the cloud on the title of anybody else. Otherwise, you'd have to go to circuit court and ask the judge to, clear the clear title action to clear this up. And so this is the easiest, simplest, most administrative way to clear up the title, so that anybody who was searching, any abstractor or title abstractor that would be searching the title, would not be confused by earlier conflicting recorded plats that were allowed but may not have actually been deeded off. And unless a tract is, like I said, unless a approved plat is recorded within a year, it expires. Okay, so that's simply, that's all we're trying to do here. There's no tricks. Do y'all have any questions for me?
Well, we will here shortly, but
Okay.
does that complete your application?
Yes, well, David would like to speak to clear up some surveying issues.
Okay. And Mr. Garber, we'll get your name and address again, just for the record.
Sure, David Garber, Garber Chilton Engineers and Land Surveyors, 2249 Commerce Parkway, LaGrange. As B said, this is trying to clear up some problems. About a month ago, I was asked to do a minor subdivision plat to create that tract right there. It was an existing home, there was an existing driveway, and there was an existing easement. So there weren't any new easements to create, no new curb cuts to ask for. The only thing that was different is, as you see here, that little tract there, all of the other right-of-way had been cleared up prior to this on recorded documents, and that little bitty piece still read out to the center line of the road. So that's what that little piece is right there. So we came and we actually we were going to make application to the Board of Adjustment because of the road frontage issue here. Well, we thought everything was fine, and then I guess Amy and Jim got together, and we had discovered it too. We ended up with a big thick file, and we were trying to figure out what in the world was going on. There were plats that were approved but never recorded, minor plats. And what happened, in my mind, what's happened is, instead of waiting for those plats to come back as part of a deed, and the GIS person then enter in the new lot, they kind of jumped the gun and they started showing lots in there that had not been recorded yet. The minor plats were approved, but the lots weren't recorded. And so now we started having lots shown that were just never recorded. So that created a little bit of the problem there too. So we went back through all the we had record plats, we had minor plats that were approved and not recorded, we had minor plats that were recorded, we had minor plats that reconsolidated properties, and from 8 different surveyors. I mean, I found all kinds of stuff. So we sat down with staff, and they came up and said, why don't we just do a record plat, bring it to you all, that's gonna clear all of this up. As Amy said, this house was actually built over the property line. The owner said, well, I owned all the property either side of it, what difference did it make? Well, the difference it made is it was still over a property line. And when this tract was created, there was an easement created, something like this. That's how they got their access. That's not the way the road, the driveway was built. The driveway was actually built over here like this, and that's how they got their access. So that's why we're requesting that we release that easement so to be gone. So again, we're trying to clean everything up on this 16 acres by this larger record plat. Like you said, there's a house here, there's a house here. This house was existing. This is the piece of property he wants to sell. That's why we created the minor plat. There's a house here, and there's a house here. And the way this configuration in here got established was that because there's a barn here, the barn couldn't exist on a piece of property by itself because it's not a primary structure. So we moved the lines around to allow the barn to be on the property with that house. Mr. Adams owns the barn, he owns the house. Now everything is legal there as far as we're not violating any other regulations. And I talked with Amy a few days ago about this Tract A. You know, I'm saying, well, it doesn't have any road frontage. Do we need another, easement for it? Or do we need another variance? And then she brought up the fact that, if a house is ever built there, which at this point in time, there is no plan for it. At least we weren't told there's a plan. If it's built on R2, it will be legal. The lot doesn't need any variances. There's no waivers needed. And that will clean it all up. So the idea was to create this plat, which I believe you all have in front of you. And if this plat can be approved, if you all approve this plat, then it can be recorded, and everything on here now becomes within all the regulations, and all of the lots can be drawn as they should be in the GIS system. The way it's drawn now, not only did he have lots in there that weren't supposed to be there, they were wrong. The lines were wrong. And even though if you go get a drawing, they'll say that these aren't exact, it's not based on the survey, but this was really bad wrong. And it's just, it drives you nuts. But this cleans it all up. That's all we're doing is cleaning up. No more building permits are being requested. No more curb cuts are being requested. No easements are being requested. We're moving that one easement. The driveway exists, but we're never just going to put an easement around it. And that is right here. This driveway already exists all the way back. All we're doing now is we're going to put an easement around it. And I've described that. We've located it in the field. So we've located the driveways, we located the houses. So everything on this record plat is truly as it exists on the ground. And that's all we're requesting today, and we ask that you all approve it so we can clean this up once and for all. Thank you.
All right. So I'll ask the attorney here, Mr. Craigmile, does this complete your application? Yes. Okay. All right, the docket PZ 16017, we'll move now into asking, is there anyone else here in support of the application? Is there anyone else that would like to be, that is here in support of the application? All right, we'll move into testimony and questioning by those opposing the application. And you have 50 minutes. So, okay, if y'all would, whoever wants to testify, would you all stand up and we'll get you all sworn in, and then we'll get your name and address when you come forward. Okay. Ms. Fox, if you'll swear them in.
Raise your hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
All righty, and whoever would like to come first, come forward. Just name and address for the record, please.
James D. Green Jr., address 3600 Halls Hill Road.
3,200.
3200, I'm sorry. We own Track E.
Track E, okay.
Yes, and one of my first concerns is, I'd like to see a survey of what is actually there right now, not what's proposed. The easement to our property is on the left side here.
You can draw on the screen there if you would, if
But
you,
our easement to our house is right here. And I'm not so sure that he hasn't built a home and a garage on top of our driveway easement, even though we have been using this entrance that was already in when we purchased the property. But our easement's actually over here, so I'm at this point, I'm not willing to give up our easement to our property until I better understand this whole situation. Also, my concern is that in the future, we bought this because of the conservation type area and serenity back here. I'm not so sure this won't be subdivided into 2 more tracks that go out this way, and which would, create more of a subdivision atmosphere.
And we also don't feel like the lines on this side, as indicated, are accurate.
Ms. Green, I would assume you're, Mr. Green, just want to get your name for the record, please, too, if you would. I didn't catch it. a
I'm
minute ago.
sorry.
That's okay. Just
Cynthia Green.
Cynthia, okay.
Greene.
Okay, go ahead.
And so we'd have some questions about how this is displayed on your screen here.
Okay.
And those are our biggest concerns, as my husband mentions, on the possibilities of what would take place on Track A with further subdividing and the easement that impacts us, and just the discrepancies that exist with the entire.
And probably, is Mr. Gerber,
Yes,
he
we'll get
could
him to-
probably share with us whether or not the recent house that was built on Track C and garage, whether they're both on the easement or not.
Mr. Garber, would you come up, please, and address that?
Yes, the existing easement is shown here in the hatch, okay? And right up about like that. And yes, that house, as it exists now, is on top of that easement.
And the garage also? The new garage?
second.
The new garage and the new house?
No, the garage
Okay,
is not, the garage
But
is
the
not.
house is on our.
The
our
house,
easement.
right, and my understanding is that was actually, this roadway, some of it was taken out. It doesn't, the roadway itself doesn't go all the way back over here.
It wasn't a true road in the fashion of a road. It wasn't gravelled, it's dirt. It does
Dirt.
have an entrance gate, and I believe it's paved up to the farm gate that swings open. And Mr. Adams' intentions were to use that for a road because he had an elderly father living with him. And in the event that this other driveway was not accessible, it was his intention to use that entry of that easement where the farm gate is, that was intended to be a road, to access his elderly father if necessary.
Would you show on the screen where that gate is that you're talking about?
Well, it's close to Halls Hill, I'm sorry.
That's all right.
I'm butchering this. It's close to right there, and then there's a little paved area that comes up to it. So the gate is approximately there, and then the easement comes on in.
The main concern is he's built a house on our driveway easement. If it's being subdivided out and stuff like, well, he is whether or not it's been divided or not, it's on.
Okay.
Let me ask Mr. Carter, legally, what, if there's an easement that's been built on or over the top of or whatever, what can happen? What's the authority of the commission? What can we do to correct, to correct that? It's already been done. So what's the options here for the commission to consider?
It probably shouldn't have been permitted.
I honestly don't know. I don't think we can take away an easement. We don't have that authority. I don't, is this a deeded easement?
Yes.
We can't abolish a deeded easement.
Well, that was going to be my question when we got to the questioning time, because,
Yeah, we can't do that.
okay. Well, go ahead, I'm sorry, I didn't want to, but you all have anything else that you'd like to add?
Not at this point, but we'd like to be able, ability to come back up if we
Oh,
need to.
sure, absolutely. Yep.
Thank you very much.
Let me ask Mr. Garber something. How long is,
Excuse me.
do you know how long the house has been built on top of the easement?
Maybe,
Okay,
yeah, I was gonna say maybe a year and a half at the most.
Okay.
but you all do use this one now?
We do use that one.
Okay.
That was existing driveway was there. We hadn't incurred the cost of putting in the driveway on our easement. And when we bought the property, I told her, I said, that's an issue. That easement needs to be corrected probably. But right now, it looks like we may have Mr. Adams over a barrel, so to speak.
All right, well, you'll certainly have an opportunity to come back up. We'll ask if there's another gentleman, I think, wants to come up and provide testimony or have some questions, so, thank you all. And we'll name and address, please.
All right, for the record, my name is Gregory Jones. I live at 3116 Halls Hill Road, also known as Tract D in this plat. My wife was gracious enough to type up a letter to kind of represent many of the neighbors, and we're not able to get it submitted to you all in time. I have copies if you all would like it, but I'd also like to read it verbatim into the record. So if anyone would like copies, I have it.
Yeah, guys, put it on the screen,
Okay.
on overhead. We can.
And then I'll elaborate a little bit after that. We can straighten that up a little
And you
bit.
have to understand, if you're providing testimony from this letter, we do require folks to be here to,
Correct.
be cross-examined where we can ask them questions, things like
Correct.
that. So, I mean, you can get it into the record, but, we really can't consider it if it's testimony from folks that aren't here.
Correct. And I believe we all are here except
Oh,
for one.
okay. Okay,
Except for
good.
one couple, I believe we
Okay.
are here.
All right.
Okay. And also, everyone left in this courtroom who hasn't spoken yet is in opposition to this, this proposal. This letter is in opposition to David Adams's application hearing for a variance request of the address of 3160 Halls Hill Road, parcel 22-00-00-3 by the Oldham County Planning Commission, docket PZ 16017. The application submitted by Mr. Adams has a request to sell off 2.585 acres from the parent tract of 16.82661 acres, which includes parcels of land that have been previously sold to the owners of 3100 Halls Hill Road, 3116 Halls Hill Road, and 3200 Halls Hill Road. Thereby, the tract does not appear to be of measurable value for the application, and a new survey of the actual parent tract land involved is deemed appropriate by landowners of the surrounding area, as Mr. Adams refers to as his neighbors. In addition, Mr. Adams has incorporated a Tract 4, originally, I believe it's now a Tract, we had Tract A, of 3.50 acres into this new and revised plat map, where he has stated he will be selling off the land with the barn that is adjacent to that tract, but not incorporated within the tract. This tract was, I believe, Tract A, and is currently split by R2 and CO1 zoning. When considering all setbacks and acreage for septic, the property that is in question only has one suitable building location, and that would probably and most likely overcome the CO1 zoning, therefore requiring 300 foot of road frontage that is not currently possible. Mr. Adams has also spoken directly to me, saying that if someone should build on the Tract A, the likely is that the watershed from that building would flood the home currently that would be Tract, I think we had down as Tract, I don't remember, I don't have the Ural's copy in front of me of what the tract looked like. But originally, the copy that we received would be Tract number 2. Tract A would be incorporated into this decision as appears the plat revised postmarked April 14th, 2016. As we adjoining property owners, we are concerned with the prospect of a decision to grant any variance, as Mr. Adams has previously, as he has stated in his application, sold off plats and not adhered to a one-year recording period, as well as other building and water issues that have occurred over the years. In addition, the road frontage variance of 206.42 feet seems inappropriate, as the parcel of Tract 2 that adjoins the shared driveway of 3100 and 3116 is not currently being maintained. We do have photographs available to the state of the property. There happens to be feral cats living within the brush that is not maintained, and we as the neighbors do maintain and clear the easements in the drive. We would request a maintenance agreement be in order with any regard with or without a variance. We do feel our notification of this hearing was within a short time period, and we've not had the proper time to acquire proper and adequate legal counsel. Our hearing notification was postmarked April 14th and received on April 16th. We have spoken to 2 attorneys, and the time frame was too short for them to represent us, or their fees were not within our budget for a hearing. On this matter, we would at least respectfully request a postponement of hearing of this docket until proper counsel can attain for all parties and can properly address the commission. Thank you all very much for your time. I would just like to add to this. I don't know if we can bring that original plat back up that we had going there. Just to clarify things if you all don't fully understand. Tract E was Mr. and Mrs. Green who just spoke. Tract D is myself and my wife. Tract B is Vincent and Laura Smith, who were not available today. Tract C, A, and F are all currently under ownership of Mr. Adams, and at this point in time are one parcel. And there are 2 homes, one of which on the proposed Tract C and one on the proposed Tract F. Obviously, our biggest concern is with Tract A, the creation of that. Much of that acreage on the back side of that is wooded and improperly suited for building. Tract A also contains the new easement that apparently has been written in for the driveway. So setbacks and requirements therefore would probably would prevent proper building on Tract A without encroaching on the CO1 zoning. For sure, who really knows? But given David Adams' history of building as it's better to beg forgiveness than to ask permission, I would pretty much guarantee that within a year or 2, we'll see a house on that lot that's spanned over the CO1 zoning. Any questions?
There'll be an opportunity for that here just shortly.
Okay.
But,
Okay, I think that's it for me. Thank you all very much for your time. I appreciate your consideration. At the very least, I really would ask of you to postpone this for another meeting and not make a decision until we can kind of round the troops up and get appropriate counsel.
Okay.
Thank you.
all right. Is there anyone else? I know nobody else stood up a while ago. Would like to testify or have questions? I know you've got to want to follow up, and I'll let you do that here in just a second. But is there anyone else that would like to testify? Okay. Come back up if you would. Need to get you back up by the microphone. It's okay.
Just for full disclosure, I just wanted to state that Mr. Adams and myself, my husband, we've had an amicable relationship. So this impacts me directly. I just want to state in disclosure that it would be our intention, if terms could be met, that we would purchase and have always indicated to purchase the existing barn on Tract C and the property of Tract A. We have maintained that property for a great deal of time by helping to mow it and keep it groomed, as Mr. Jones has done with the property behind his property for Tract F. But in full disclosure, I just wanted to state that for the record.
Okay, Ms. Green, thank you. All right, let's see here. I guess we'll move into questioning of the applicant and those opposing the application by the commission. Before we get started or open it up for questions, I've got one question, I guess, want to follow up with Mr. Carter. Can you outline for us here on this easement issue on, what we can, what the authority we have or non-authority or whatever on taking away an easement or adding an easement or?
If it's a deeded easement, we have no authority to take away an easement.
Okay,
Or
so,
abolish an easement.
so what's being proposed today is something we can't do, is that correct?
If I understood correctly, yes.
So your
I
answer,
assume they're saying that that's what they want to do. But it's a deeded easement. Now, there may be a question as to whether it's been abandoned, but that's not a question we can answer either.
okay. So, okay, Mr. Urban.
Well, between the 2 property owners, they could relinquish an easement and
Right.
accept another easement, which is what is being proposed. Now, I don't know if the Greens have actually seen this driveway that
do
goes
that.
in, but,
The property owners can do that. We can't do
yeah,
that.
we can't, but the owners can between them.
Right. Okay,
The
well,
only
I,
applicant is Mr. Adams.
okay, and I just want to be clear, I want, you know, so the commissioner will understand that we don't have the authority to dissolve an easement. I mean, they can do that with the affected property owners, but that's something we can't do today. Excuse me. So,
If they want to do this, they would have to get the easement resolved and then come back.
Before this could be recorded, that easement would have, arrangement would have to
Right.
be worked out,
okay,
unrelated to the planning commission.
okay, I just want to make sure that everybody understood, or understands that. So now, is there any questions from the commissioners for the applicant or the folks that have testified in opposition? Any questions? Mr. Horton?
Yeah, to the applicant there, whether we were to grant or not grant this easement, how would that affect the property? I mean, how would it affect your client?
Are you talking about this one here or
The
this?
waiver down there, from the 93 feet to the 200 and
Oh.
something or other.
Well, then the minor plat that we asked for it to be recorded could not be, I mean, to be approved, could not be approved without the variance.
But it wouldn't affect it in any other way. I mean, it doesn't limit the use of that property in any other way.
Well, yes, no one could get title to it. They're trying to, because we have two houses on one lot.
Okay.
That was the whole thing that we originally came in for, is to put this line in so we could sell that house off on Tract F.
Okay.
Right now, it's part of that whole, the original 16 acres.
Okay, thank you. And I guess my other question is to the chair and to the staff then. Apparently, we can't do anything until the easement is decided amongst themselves or others. Is that correct? Because if we approve this, we've erased an easement which can't be done.
Mr. Craig Miles, can you address that?
Yeah, what we're, actually, I've found, we're authorized to amend this drawing to remove Tract A from the table, take that off the table. And put the easement back on there. Now, that doesn't address the issue of the house being built on the easement, but John Carter is completely correct that y'all can't take away an easement. I mean, that's a matter of law, okay? So what we would like to do would be to talk to the Greens and you know, make arrangements with them as to what to do about this easement situation. I wasn't aware that the house was on the easement, but we're able to talk with them and grant them an alternative easement, release this easement if whatever, or if that doesn't happen, I suppose there's, you know, court issues, but, you know, nobody wants to go there, you know, in
Mr.
terms of
Craig Miles, let
their-
me, as chair, let me see, you know, if this is possibility. I mean, I don't feel as chair today with these issues, legal issues that are outstanding, that we can make a decision today. Now, you know, if you all, you know, can get together, that's fine, but I think, you know, we as a commission, my suggestion would be that we table this for at least 30 days and give you all an opportunity to get together and see if you can work out an agreement on the easement, and then bring that back for us to consider, you know, at a future hearing. But, you know, Mr. Carter, is that,
I think the best way to do this is for them to withdraw their application, and if they get things worked out, however, and then resubmit it.
Well, we could, or table it and then resubmit an amended version of the draft, so we don't have to start over from scratch, but.
I think,
That's okay, too.
I think tabling it, that would allow, you know, the property owners to come back and still have input, and you know, we would just remove it from the table next month or the month after, however long
Yeah.
you all feel it would take to get that done.
Yeah.
But I think, you know, we're being asked to do something that we can't do
Right.
from council, what council has advised us. And so, you know, I think, you know, we've already had the hearing, we've already gone through the public hearing process. If we table it, then you all would have an opportunity to come back after working out with the Greens and the other property owners on this easement, and then, present something to us that maybe that we could work with.
Yeah, that's understandable. I mean, I could understand how you could say you can't approve the plat, what it would look like if we took off A and, that's, Jim has to have an actual piece of paper that has it drawn the way it needs to go to the
Dealing with
beaver.
too many unknowns that we don't have in
Correct.
front of us here.
Question I had is, if they became party to this record plat, just like any other major record plat,
They meaning whom?
these,
Greens.
if the Greens became party to the record plat, in other words, they signed as an owner, say we negotiated with them, and they would agree to releasing this by the record plat, and they have a place for their signature on the record plat, would then, could you all then approve the basis of what we're doing, and then allow staff to approve that record plat without having to come back again?
I think I'm not speaking for the commission, but I think from what I've heard, questions and whatever, there's, still some other issues that are not resolved. The easement, I don't think is the whole total issue or whatever. I mean, we've gone through and had some questions, and we're not to the process or the point yet of making a motion to, and to do anything. But, I think it would just be cleaner if we tabled it for a month or whatever Jim and the staff needs and what you all need to get with the landowners, and then come back. I think that would be cleaner, would it not, Mr. Urban?
Yes, but without question, that signature has to be on the record plat.
Right.
That release of that access easement has to be on the record plat.
Unless it was a release by deed prior to that.
Yes. A deed of release would do the same, have the same effect.
Same
wouldn't it?
effect, okay.
Yes, but I think everybody likes, all the title search people like to see it on a record plat,
All right, let me,
Can I ask you all a question?
I think.
oh, yes, sir?
Has the commission discussed or have an opinion as to the variance issue?
No,
I mean,
we've
it's
not
a
got to that point yet, and I,
Fairly significant variance if you, consider it 200 feet, but, if we're gonna have to redraw this thing, we might be able to draw the line 1/10 of an acre over to the side, so this is really only 150 foot as opposed to a 300-foot minimum road frontage requirement. Does that make sense?
well, it does, but let me ask Mr. Carter, just to get clarification here on,
They act on a
if,
variance
should we
without
complete
acting on a
the hearing
See how they could
and
if
then
they don't
table
have it
it,
drawn
or
accurately.
table it at this point?
We do have a minor plat right here.
I don't see the purpose of continuing the hearing, actually. Because we can't actually do anything.
Right.
I don't think. You agree?
Well, if we come back with with an agreement.
Right, well, I mean.
This was
table-
originally, this was originally scheduled with the Board of Adjustments for a mere variance, in which, the variance was going to be for the road frontage.
There you go.
But then we tried to accomplish, bring it, since the Planning Commission has concurrent jurisdiction with the Board of Adjustments for variances and waivers, we thought we'd get it all done correctly and quickly and, help with the GIS system and get it corrected, because it was causing confusion. So there is somewhat of a degree of urgency on the sale, on the sell-off, because there's a current bid, application, or somebody's interested in purchasing that old house back there, and which was the primary reason why we tried to get it on so fast, is so we could just get the variance approved, so that, which is really not changing anything. It's the same road that these people have used since 1980, whenever it was built. I mean, he acquired the property in 96. That house was there in 96. They used that same road. Everybody's used that same road with the 93-foot easement. If it was just in the R2 half of this property, we could go under the flag lot exception, which only requires 40 feet. So that's what if nothing else, I was wondering if we could maybe amend it to ask for just approval of the variance, if that would be possible, Kevin.
I don't think so as chair. I want to get concurrence from the commission or whatever, but, my suggestion would be that we stop the hearing at the questioning of the applicant and those opposing the application by the commission. Table it and bring it back in 30 days or at our next regularly scheduled hearing. And start at this point, allow, both applicant and opposition to, basically start here at the questioning phase, and you all try to address the easement issue and get that worked out. I think, I just don't feel like we can move forward on the variances or anything else that being requested until we know where we are on the easements and where these lines are going to be and those kind of things. So,
That's fine, we're agreeable with that.
Well, and I want to add this, with all respect to Mr. Craigmile and Garber, this is not correcting GIS. This is a mess, is what it is. By all these minor plats that were approved and recorded or not recorded, GIS really has nothing to do with it. Yes, it will correct the GIS, but that's been the real point of all of this, is the easements, a house being built over an easement. This is a better picture already, what you have today, than what we've ever seen, thanks to Mr. Garber's hard labor in trying to sort it all out. So I agree that there are still some questions related to this that have nothing to do with GIS, but again, what do you do with these easements, and then tract 4 in the back, and I think that's the big question here, and the neighbors are concerned, and at least tabling this at this point is a good idea.
okay, and as chair, I would ask then is if we could get a motion to at least consider, tabling, and I'll ask them to come back. Are you all, as commissioners, okay with that outline as far as, coming back in 30 days and address these issues, especially on the easements? Yes. Because those have got to be addressed, I think, first thing. So, do we have a motion then on? So moved. Okay.
Second.
Okay, motion and second. It's non-debatable, non-amendable, comes to immediate vote, and the motion would be to table until our next regularly scheduled meeting, which would be the 4th Tuesday in May. I don't have that date, but, and that'll give you all an opportunity to get with the landowners and make sure that you can get this easement issues worked out.
Okay,
So,
thank you.
Well, we can't debate it.
No, I'm not, we haven't voted yet, have we?
No, we have not, we haven't voted, right? No, we have not.
Well, I'll let
So-
us vote, and then I'll ask
Okay.
for your.
All those in favor of tabling docket PZ 16017 until 30 days from now, which will be our next regularly scheduled meeting in May, which is the 4th Tuesday, May 24th, signify by saying aye. Aye. All opposed, no. Okay, it has been tabled. Mr. McWilliams?
Mr. Chairman, I would ask that staff take a look at this again and help the commissioners on the concerns and the questions and whatever before we reconvene. Their level of expertise far exceeds mine. I'll only speak for me.
Okay.
But I think it would be helpful to us for that to occur prior to the next presentation. Pulling it off there. Thank you, Mr. Chairman.
All right, we've got one other item of business, under other business, and I assume Ms. Alvey is going to present that. It's an extension of expiration of Wolf Lake Estates, Carter Manor.
We have training hours too.
I'm sorry?
Training hours,
Oh, yes. And, yeah,
we'll do that after.
okay. Got some issues or some questions, I guess, about training hours also.
Well, no, we had 3 people that went to training.
Oh,
That
correct.
we need to clarify that on there.
Right.
This is just to get it in the record that, Carter Manor, which is also known as Wolf Lake Estates, it was, went before the Planning Commission back in 2005. They filed for an extension of expiration on
If you
May.
would, folks, if y'all would step out of the courtroom, we still got a little bit of business we got to take care of, so.
It was set to expire May 31st of 2016, and they have filed for another 2-year extension. So I just wanted to, you all previously approved extension of expirations. They could be reviewed at staff level, and then we send that out to all the agencies to receive comments back. There were no comments back with any concerns from the utility agencies. So then it's approved at staff level, but I just wanted to make sure it got into the record that the new expiration date is May 31st of 2018.
Okay. All right, any questions on that, commissioners?
That's not a question. I just think that the complexity of that last one, I just want to say great job to staff for being able to
Yes.
muddle through that. I thought I was having a nervous breakdown.
Well, it's not resolved yet, but, you know,
I
I
was
think,
having a brain freeze.
But good
We,
job.
we also had three planning commission members, Ms. Crosby, Dr. Arvin, and Ms. Albertson attended the Regional Mobility Transportation Summit. It was from 9 to 4, is that correct? Okay, it was 9 to 4, so if we could get a motion to put that towards their training credit hours for the year.
okay, could I get a motion for that?
So moved.
Okay, and a second, all right. Any discussion? All right. All those in favor of for approving those training hours for those three commission members signify by saying aye. Aye. All opposed? Okay, thank you all, and we will have a
We
meeting
will
next
have a
month.
planning commission meeting next month. We'll have the first agenda items that were docketed, or that were moved to the May hearing for the rezoning on Washington Street. We will have this case, and we've already had one application filed for another waiver. So we will have so far, and filing deadline is tomorrow, so.
Right, and also remind everyone, we're having on Saturday at
9 to 12, we are going over the proposed changes that you all recommended to the legislative bodies. We're having a public meeting at the John Black Center on 393. It's from 9 to noon, and it is a public meeting. Everyone's invited.
So if you can make it, you know, it'd be great, it'd be greatly appreciated. I'll be there, and Jim and the staff will be there, and so we're gonna try to, you know, talk about what we've done for the last 2.5 years or whatever,
Correct.
so,
Hopefully, this will help move it forward to the legislative bodies.
right. All right, with that, folks, we will stand adjourned, and thank you all. We'll see you next month.
What got interesting?
It did.